Good afternoon, everyone. Thank you for joining us for today's rendition of our Business in 2022 weekly webinar series. We have a great lineup for you today. We have 4 speakers. We are first going to hear from Ray Pascucci, who's going to talk to us about the recent tidal wave of unionization efforts. I think over the course of the past several years, we've been anticipating at some point that we were going to see some pretty stark increases in unionization efforts. And I think what you'll hear from Ray today is that we are finally seeing the fruits of those labor from organized labor. Next, we'll hear from Janelle Dubey, and she's going to talk to us a bit about New York State's pending wage transparency law. Carrie Langan will be up third, and she is going to walk through some pending and potential future human rights law updates. And then last, but very not least, is Kate McClung, and she's going to talk to us a bit about avoiding wage and hour class action lawsuits and some best practices with regard to that. Ray?
Okay, thank you, Erin. Good afternoon, everybody. So I'm just going to spend a few minutes updating you on the world of union organizing. Some of this you'll recognize from the news, but back in December, the first Starbucks store in the United States was unionized. That happened in Buffalo, close to home. And since then, 250 stores have voted for a union, and 54 have voted for a union, 250 have petitions pending. So it started with one, and it's become a pretty significant wave of unionization at a company that has long had the reputation of being an excellent employer in terms of how they treat their associates and their benefits, et cetera. So Starbucks obviously is a big brand. Google is another one. In March, the first group of Google workers voted for a union in Kansas City. Amazon, which we all probably read in the news, lost its first union election ever, involving 8,300 employees in Staten Island in April. And Apple, this past weekend in Baltimore, had their first Apple store unionized. That happened on Saturday, June 18th. So there's a lot happening, and it's not limited to, ordinary businesses or smaller businesses or local institutions. It is hitting some of the biggest employers in the country. There seems to be another trend in union organizing. First of all, it's widespread. It's in every industry. And I'll get into the reasons for that. But another big trend is for the folks downstate. There was a statute, a recently enacted New York City statute requiring contractors and subcontractors with the city who provide city services to enter into a labor peace agreement, which essentially means a neutrality clause and a card check recognition agreement, making it much easier to organize their employees. And so unions are very busy targeting those small not-for-profit organizations and social services agencies. That's in combination with what we're seeing on a national scale. And as I mentioned, the national kickoff for some of these big companies was homegrown here in New York State, both at Starbucks and at Google, but it's not limited to New York State. Why is this occurring? I mean, it's all about COVID, frankly, the COVID-19 pandemic. If you look at, well, there's more to it than that. The stage was set, but over the past 6 months, from October, for which we have data, from October of 2021, last quarter of last year, first quarter of this year, through March of 22, union representation petitions for the NLRB have increased 57%. The labor market, we all know, is reeling. There are currently about twice as many job openings as there are unemployed people looking for work. Terminations and layoffs have reached a record low, and the number of employees quitting their jobs is at an all-time high. This has made employees who are dissatisfied with their jobs in one way or another more willing to demand better working conditions, including through unionization, if they believe that that is a way to achieve the objective. A Gallup poll in September of 2021 showed that 68% of Americans approve of labor unions, which is the highest rate in nearly 50 years. It was 71% in 1965. It's been much lower ever since then, and now it's 68%. So it's at a sort of almost a historic high. That's just a general poll about whether you approve of labor unions or not whether you want to join one, but it's important. The pandemic was a wake-up call, prompting people to reevaluate their work-life balance and their relationship with their employers. The former NLRB chairman, Mark Pierce, is quoted as saying, the vulnerable workers were not only scared when they were required to work during COVID, they were pissed because they felt as though they were being, forced to work when it was dangerous. Zoom made people question, Zoom and similar technologies made people question the need to leave home for work. Social media provided a convenient platform for internal and external chatter about discontent with the workplace. President Biden vowed to be the most pro-union president ever, and he's followed through on that with his appointments. So it's a perfect storm, and we're seeing the results of that. So very briefly, I assume probably a lot of you are familiar with generally how labor organizing works. There's a federal statute, the National Labor Relations Act, which gives employees the right to choose. And the way they do that is through normally through an election conducted at the workplace by the NLRB, and a majority decides whether it'll be a unionized group of workers or not. There was, up until very recently, a very long-standing decline in unionization in the United States. Unionization peaked in 1954 at 34% of the workforce, and this is private sector, by the way. At the end of 2021, it was down to 6.1%. So, 94% of the workforce, private sector workforce, is non-union today, compared to, a 1/3 unionized back in the 1950s. And that was for a lot of reasons, which we could spend a long time getting into, which I won't. But I think the biggest reason may be that, the government has taken the role of a union in many ways. There are a lot of statutory rights in the workplace, rights about, overtime pay and minimum wage and anti-discrimination, et cetera, family leave. Everybody knows, have really done a lot that unions used to have to negotiate for. So that's been a big reason. But labor's been trying very hard to reverse that trend, of course. And what's happened recently, first of all, in 2019, which was the last presidential election year, the unions really spent most of their time and resources engaging in political action. They really did not do much organizing. In 2020, during the shutdowns, which was at least the first half or a good chunk of 2020, it was very hard to organize because people weren't at work, weren't coming to work, which was the traditional way of organizing, was face-to-face at work. So finally now, latter half of 2021 and now 2022, that's opened up to a large extent. And people are upset for, pandemic-related workplace fears are still a big issue. Pandemic-related burnout is a big issue. Workers feeling underappreciated. Here in New York State, workers feeling underpaid, particularly in light of the hikes in minimum wage. Recruitment and retention problems, staffing shortages as a result of that. The pro-labor administration in Washington. And of course, we've, for a long time in New York, had a very labor-friendly political climate, both in Albany and in New York City. So all of that combines to get us to where we're at. Another maybe bigger picture set of factors that's at play here is sort of the new worker mindset. And these are generalizations, but most millennials and subsequent generations have a different attitude toward work than preceding generations. They do not expect to stay with the same employer for their entire career, and thus feel less a sense of loyalty. They're less interested in deferred gratification and expect frequent increases in pay and rank. They place a higher value on work-life balance than career advancement in many cases. They insist on fair treatment, inclusion, and a workplace that demonstrates social consciousness. And they are demanding flexible work arrangements. And all of these trends, which pre-existed the pandemic, have been accelerated by the pandemic. So poses a lot of challenges for employers. Another factor is, and I'm almost out of time here, but political correctness is a big issue in the world of unionization. Unions are promoted as agents for social justice. I mean, certainly they have a history of making a valuable contribution. Any dissenting opinion about the purported benefits of unionization is branded as anti-union. Any effort to educate employees about the downsides of unionization is branded as union busting. And so there's a lot of pressure, both, from peers, peer-to-peer, and in general in our society today. So, I could carry on for a lot longer about how organizing works, but I just wanted to give everyone an update. We're seeing a tremendous upsurge. Your organization needs to be prepared for this. You need to think about training your management level folks so that they understand the organizing process. And most importantly, thinking of ways to show that you care about your employees and that you are committed to positive employee relations, listening to them, receiving their feedback, being responsive to their needs and concerns, et cetera. So I'll stop there and, of course, answer any questions.
Thanks, Ray. And just dovetailing off that a little bit, in my own practice, I've seen an uptick in the number of election petitions filed with the National Labor Relations Board for elections, certainly an uptick in organizing activity. I've also seen an uptick with clients in terms of, to your point, Ray, taking proactive steps to try and avoid unionization before there's a campaign. I think it's long been the best practice that it's much easier to try and avoid unionization before there's an active organizing campaign. And I know a number of clients that I work with have done supervisory training and are trying to actively communicate with their employees about what they do that's great for them to try and avoid the headwind a bit. So, Ray, thank you so much for your presentation. We really appreciate your insight on this, and maybe we can have you back so you can give some more insight in the next few weeks. So thank you.
All right, thank you.
All right, now we're going to shift gears a little bit, and Janelle is going to talk to us a little bit about the pending wage transparency law here in New York State. As some of you may know, on the program, New York City recently passed a wage transparency law, and not surprisingly, it looks like the state is following in those footsteps. So Janelle, and for the audience, there are no slides associated with this presentation. So Janelle is just going to talk to us about the pending law. Janelle?
Thanks, Erin. So as Erin said, I'm going to talk about New York's statewide pending wage transparency law. So recently on June 3rd, the New York State Legislature passed a new statewide wage transparency law. This law would effectively amend the New York labor law and add section 194B where the law would be codified. So if enacted, the new law would require covered employers to disclose compensation or range of compensation to applicants and employees upon issuing an employment opportunity via a job posting for internal or public viewing, or upon the employee's request for such information. So the purpose of this bill is essentially to enhance transparency around compensation and reduce any existing wage disparities among employees. The law seeks to address systemic pay inequity and discrimination by mandating that employees who are covered under the law disclose compensation information to applicants and employees. So employers covered under the law who must comply with the law's requirements include, first, any person, corporation, limited liability company, association, labor organization, or entity that employs 4 or more employees in any occupation, industry, trade, business, or service, or any agent thereof. And also covered employers include any person, corporation, limited liability company, association, or entity that acts as an employment agent or recruiter, or otherwise connects applicants with employers, provided that an employer does not include a temporary help firm as that term is defined under New York labor law. So the law requires these covered employers to disclose certain information in job postings, not just for initial employment, but also including promotions and transfer opportunities that can be performed at least in part in New York State, which means this is probably going to apply to remote workers as well. The information that must be disclosed under the law is, first, the compensation or the range of compensation for such job, promotion, or transfer opportunity. And you also must disclose the job description for such job, promotion, or transfer opportunity, if such description even exists. The law defines range of compensation to mean the maximum and minimum annual salary or hourly range of compensation for a job, promotion, or transfer opportunity, which a covered employer believes in good faith to be accurate at the time of the job posting. The law also specifically addresses jobs which are based on commission. So for positions that are paid solely on commission, covered employers can comply with the law's disclosure requirements by just providing a general statement that compensation will be based on commission. The new law also prohibits employers from refusing to interview, hire, promote, employ, or otherwise retaliate against applicants or current employees who decide to exercise their rights under this law. The law provides that individuals who are aggrieved through a violation of Section 194B to file a complaint with the New York State Department of Labor. Violation of the new law's requirements or any subsequent regulations implemented for the law could result in civil penalties for covered employers pursuant to New York Labor Law Section 218. Section 218 generally provides for civil monetary penalties for non-wage related violations, and the penalties range between $1,000 and $3,000 to be assessed by the Department of Labor. Also under the law, covered employers are additionally required to maintain records of their compliance. This would include history of compensation ranges for each job, promotion, or transfer opportunity, as well as keeping records of those job descriptions if applicable and those job descriptions exist. So employers have to keep records of the way that they're complying through providing the certain information to employees and applicants. The bill additionally requires some action on the part of the New York State Department of Labor itself. So the DOL is required to establish a public awareness outreach program in an effort to inform employers of the new law's requirements through posting on its website and also otherwise just making the information available to covered employers. The bill also provides that the New York State Department of Labor has the authority to promulgate rules and regulations to assist with the enforcement of the new law. So as Aaron mentioned, this law is similar to New York State's wage transparency law, which was enacted this year and takes effect November 1st of 2022. New York's pending wage transparency law also follows suit of several other states that have enacted statewide wage transparency laws, such as most recently Nevada, Connecticut, and Rhode Island. So we can see there's a trend throughout the US of the enactment of these statewide wage transparency laws to address this systemic inequity and also any discrimination within compensation. So as of today, the bill has passed both the Senate and Assembly, and it will now be delivered to the governor for her consideration. Upon delivery to the governor, she'll have 10 days to either sign or veto the bill. If it's signed and effectively enacted, the bill will take effect 270 days after it becomes law.
Thank you, Janelle. Not to put you on the spot, but do you have any thought as to whether or not the governor will go ahead and sign this pretty quick? Is there any thought that there would be a delay?
A lot of the articles I've read don't anticipate a delay, especially because New York City just enacted their wage transparency law. So in my personal opinion, I think it will likely be signed pretty quickly.
All right. Thank you so much, Janelle. We really appreciate this quick summary. I anticipate that we'll probably have you back on this program once the governor signs it to go into this in a little bit more depth. I know we have a number of questions in the Q&A, which just given our time constraints now, we'll probably push off, but I'm sure that you'll have some follow-up, Janelle, after this program. So thank you. All right, and our next presenter is Carrie Langan. Carrie is going to talk to us about a few updates with regard to the human rights law. So Carrie, take it away.
Okay, hi, thanks, Erin. Hi, everyone. I'm going to spend a few minutes this afternoon just giving you a quick update about several pieces of legislation that we've been monitoring regarding amendments to the New York human rights law that increase protections for employees. So if you recall, we reported on this back in March, the beginning of March. There were several bills at the time. Some had passed both the Senate and the Assembly, and others had just passed the Senate and they were waiting with the Assembly for consideration. So on March 16th, 3 of the bills were signed into law by the governor. And I'm going to spend a few minutes now just recapping those for you. The first is Senate Bill 3395B. And this law amends the definition of employer under the New York Human Rights Law to explicitly include the state, New York State, and public employers generally. And this is just to ensure that New York's anti-harassment regulations protect both public and private sector employers. The amendment also clarifies that the state is considered the primary employer of anyone serving in the executive, judiciary, and legislative branches, including the staff of elected officials and judges. And this law took effect immediately. So it was effective on March 16th. The second bill that was signed into law here on the PowerPoint is Senate Bill S5870. And that law amends the human rights law to prohibit employers from disclosing or releasing a personnel file, an employee personnel file, in retaliation for that employee opposing discriminatory practices, such as filing a complaint or testifying or assisting in any proceeding. There's an exception to this for times when releasing a personnel file is necessary or required to respond to a complaint, a civil or criminal action, or judicial or administrative proceeding. So for example, let's say that you have an employee or a former employee that has filed a Division of Human Rights complaint against your company, and the division has requested a copy of the personnel file, and this comes up quite often in the request for information. Since this is an administrative proceeding, you can feel comfortable disclosing the personnel file to the Division of Human Rights without having to worry about the individual turning around and amending the complaint to add a retaliation claim. So I think it's a good thing that that exception is specifically carved out in the law. This law also took effect immediately on March 16th. Okay, the third bill here, the last bullet in the PowerPoint, Senate Bill S812B. This law amended the executive law to require the Division of Human Rights to establish a toll-free confidential hotline for complaints of workplace sexual harassment. And the hotline is going to operate during regular business hours. It's going to be staffed by pro bono attorneys experienced in providing counsel on sexual harassment related matters. The law also requires the division, in collaboration with the Department of Labor, to add information regarding the hotline and all required to all workplace posters and other sexual harassment materials. So what I think this likely means is that the Division of Human Rights is going to amend its model sexual harassment policy to include the hotline, which would then mean that employers would all have to amend their sexual harassment policies to include information about the hotline. Because if you recall, when the law was passed regarding sexual harassment policies, you had to make sure that your policy conformed to the division's model policy. So this isn't specifically carved out in the legislation, but I think it will be wise to now amend our policies to include information about the hotline. This law doesn't take effect until July 14th. So we'll wait to see what the division does with respect to its model sexual harassment policy and then act accordingly. The other two things that I want to mention, there are still 2 bills pending with the Assembly that are worth, just another mention so we don't lose sight of them. And that's Senate Bill, the first one is Senate Bill S849A. And this bill would extend the statute of limitations for filing a discrimination claim in court from 3 to 6 years. So employees will now have double the amount of time that they currently have if this bill is signed into law to file a lawsuit in court alleging unlawful discrimination. And the counterpart to this is Senate Bill S566A, which is also currently with the Assembly. And if passed by the Assembly and signed by the governor, right, it would amend the human rights law by extending the statute of limitations to file a claim with the Division of Human Rights. So not in court, this one's with the Division of Human Rights, from 1 year to 3 years for all discriminatory practices. So if you recall, a while back, the law was amended to change the statute of limitations to 3 years, but it was for sexual harassment claims only. So now if this bill is passed, it would be 3 years to file any type of discrimination claim with the division. So it would be easier in that sense, but also giving employees an additional 2 years to file claims against their employers. So that's really it in a nutshell. I think I would encourage everyone. Oh, one other thing I wanted to mention. These laws, if they are passed by the assembly, the last two that I mentioned regarding the statute of limitations, and if they're signed by the governor, they would take effect 60 days from the date of the governor's signature. So we would have a little bit of time. And so my last concluding remark was I was just going to encourage you to subscribe to our blog if you haven't done so already. And if you currently subscribe, continue to monitor the blog, because we will have updates about all of these legislative developments.
Thanks, Carrie. I'm really intrigued, I guess is the right word, by this hotline. Do you know if the division is actually up and ready to roll with this effective the middle of July?
I have not heard anything, but it doesn't surprise me because the division's known for just, amending the model policy without telling anyone they've done it. And so I think what I plan to do is just to keep monitoring the website to see what the division has done. And, I think that's probably, I don't expect a major announcement. I think it'll just be amended and quietly done, but we'll see. I haven't heard anything specifically, Erin.
All right. The other thing that I was thinking, which may interest no one but me, but the fact that they're having attorneys staff the hotline, are those attorneys, who are they, right? And if there can be conflict issues depending on what kind of work they do, it just seems like there will be some hiccups along the way on this. And what's the outcome? So does the attorney give legal advice and then the person's supposed to act on the legal advice? I mean, I'm just trying to wrap my arms around how this hotline, like what is the policy behind this hotline?
Right. I've thought the same thing. I wondered whether it would be a division appointed attorney, that would be running. I have no idea, but then you're right about the conflicts. Then if they give advice, are they then conflicted out of handling a matter if it goes to public hearing? Kind of like with the attorneys that represent you. Well, I guess they would. Yeah, I think there'd be conflict issues. Maybe not. I'm not sure how it's going to work.
Yeah. All right. So we will keep our eyes on that as it progresses and as the hotline is rolled out. I'm sure we will learn more about the impact of that. So thank you, Carrie, and thank you for the update on the new changes and what we need to be looking out for over the next several months. And last but very not least, Kate McClung, who is our wage and hour class action guru, is going to take a few minutes to update us on some trends she's seen and some best practices that you can do now to address some of the trends that she's seen in the wage and hour class action world. So Kate?
Thanks, Erin. So as Erin mentioned, I do handle a lot of wage and hour class actions, and I often get clients who are very surprised that they've received a wage and hour class action. If you could go to the next slide, Kathy. So a lot of people expect, class actions are something that happens to other companies like Walmart and Amazon and these massive corporations. They could never happen to me. And that's actually not true. So to bring a wage and hour class action under the federal law, the Fair Labor Standards Act, it just takes one employee, and there needs to be some other similarly situated employees, but there's no number requirement. They don't need to be similarly situated to 100 or 1,000 other employees. There just need to be other similarly situated employees. And that's it. That's all it takes for them to bring a class action under federal law. Under state law, they do have to show that there's numerous other employees with the same type of claim. But the numbers requirement can vary. Some courts have held that 40 other employees is enough. Some courts have held there only need to be 25 other employees with a similar sort of claim. So class actions are certainly not something that only happens to massive corporations. This is something that can happen to most companies. Next slide, please. So why should you care? So there are a lot of penalties associated with wage claims, and they can add up very, very quickly. So just to give you an example, one of the types of claims I'm going to talk about briefly today is spread of hours and split shift claims that require employers in certain circumstances to pay an extra hour at minimum wage to employees. So let's say we have a company, ABC company, and they weren't doing this. And they have about 100 non-exempt employees, and they missed about 1 hour per week or $15 at minimum wage downstate per employee is what they didn't pay. So not a huge amount of money for any single employee for any single week. But if one employee filed a class action and won on this issue, which is likely if they weren't paying, it adds up. So they can go back 6 years. And 6 years just for the back pay is about $468,000. The employees can also claim an equal amount in liquidated damages, which means another $468,000. They get prejudgment interest at a rate of 9%, which is over $200,000. And they would get their attorney's fees and costs. So I would estimate the value of this case, even though the transgression doesn't seem that major, at about $1.5 million. So these cases can be very, very expensive to deal with. Next slide. So we tend to see trends in class action cases. Employee side firms that take these cases tend to file numerous cases on the same type of claim. They have a boilerplate complaint they use. They have boilerplate discovery requests that they use, and they just use these same documents over and over again and just change the employer name at the top. So some trends that we're seeing right now, one, as I mentioned earlier, is spread of hours and split shift. So this is a requirement for any of your employees in New York State. The split shift means that there's a split in the day. There's a break of more than an hour. Spread of hours means that the interval between the very first minute worked that day and the very last minute worked that day is more than 10 hours. So this isn't the same as hours worked. It includes time off for meal breaks, rest periods, any other breaks during the day. But if that from that first minute worked to the last minute worked is more than 10 hours, then they have a spread of hours issue. So next slide. So what's required to be paid? So New York has, for private sector employers, things called wage orders. And there's some for specific industries like hospitality and building services. And then there's a miscellaneous wage order that applies to everybody else. So for employers covered by the miscellaneous wage order, this requires employees be paid 1 extra hour at minimum wage whenever they have a spread of hours of more than 10, whenever there's a split shift, or when both situations occur. Now, importantly, if both situations occur, that doesn't mean they get 2 extra hours for that day. If both of these things occur on one day, they still just get 1 extra hour. There is a potential offset. The New York Department of Labor has said that you can take an offset for any amount you pay that employee for that day over minimum wage. So if this is an employee earning more than minimum wage, you could have that offset for that day. Now, if an employee is making enough over minimum wage, they may not be owed anything extra for spread of hours pay. So this is really an issue for employees earning minimum wage or somewhat close to minimum wage. For hospitality, it's a little bit different. There is no split shift pay requirement. There's only a spread of hours requirement. And here there is no offset. So even if the employee were earning over minimum wage, they would still be entitled to the spread of hours pay. Next slide. So a lot of people get confused about how the offset works in the miscellaneous industry. So I'm just going to go through a quick example. So an employee working at a manufacturing plant in Rochester works 1 day this week from 6 a.m. to 12 p.m. and from 3 p.m. to 5 p.m. So they have 8 hours worked. But again, neither of these things is measured by your hours worked. Spread of hours is from that first minute at 6 a.m. to the last minute at 5 p.m. That's 11 hours. So that's more than 10. So that's triggered. There's also a split shift because they have a 3-hour break in the middle of their workday. So there's a split shift too. So if either of these were met, they get an extra hour at minimum wage. And because both of them are met, they get an extra hour at minimum wage. So how does the offset work? If the employee's hourly rate is $14 per hour, that's more than the minimum wage in Rochester, which is currently $13.20. And I apologize, but I'm going to do a little math. I have it all spelled out here, though. The employee is legally required to receive at least 9 hours at minimum wage for this day. So that's the 8 hours worked plus the extra hour for the spread of hours split shift issue. So 9 hours times the minimum wage is $118.80. To calculate the offset, you figure out how much their pay is at their actual hourly rate and see what the difference is. So their actual pay for $14 an hour times 8 hours actually worked is $112. So based on your agreed upon rate, you're already paying them $112. They have to legally receive $118.80. So for spread of hours, split shift pay, you owe them an extra $6.80. So not the full hour at minimum wage. The full hour at minimum wage would be $13.20. And if this employee was in the hospitality industry, because there's no offset there, this employee would get that full $13.20. But in the miscellaneous industries where you get the offset, you would only owe that lesser amount, that's $6.80. Next slide, please. Okay, another issue that we're seeing a lot of class actions on is rounding. Rounding simply means that you don't pay people based on the exact time they punch in and punch out. You round it to the nearest 5 minutes or 15 minutes or another interval. So this rounding is permitted, but only under certain circumstances. And if you don't comply with these requirements, you could face an individual claim or a class action for rounding. It's also something that could come up in a DOL audit, either a US DOL audit or a New York DOL audit, because this is a requirement under the federal law. So this applies to all of your employees within the United States. So rounding is only permitted where you round to certain intervals. You can round to the nearest 5 minutes, 1/10 of an hour, 15 minutes. You cannot round to the nearest half hour or some larger interval. And you can only round in a way that doesn't fail to compensate employees for all hours worked over time. So that just means that the arrangement should average out so employees aren't being underpaid on average over time. So some ways that employers get into trouble with this is they only round when it's to the employer's benefit and not to the employee's benefit. So for the start time, say someone starts at 9 a.m. and they clock in at 8:55, and so they clock in early and the employer rounds to 9. But then if the employee clocks in 5 minutes late, 9:05, well, then they measure it from the 9:05 and they don't round. That would not be permitted because you're not rounding both in favor of the employer and the employee, and the employee is only losing out on payment. They're not benefiting from the other side of the rounding. You have to round both ways. Another problem that employers can get into is if you round both ways, but then have policies of disciplining an employee for certain things that in effect takes away that reciprocal benefit. So going back to my example of someone who starts at 9 a.m., let's say you round both ways. So whether the employee punches in at 8:55 or 9:05, you round to 9. So far, so good. But then the company also has a policy of punishing employees who punch in late or who punch out early. So if the employee punches in at 9:05, it's going to round to 9, but they're going to get a warning in their file. And if they keep doing it, they're going to get fired. Well, your employees aren't really going to punch in late and get to take advantage of the rounding in their favor when you have that kind of policy. So that's another way that rounding policies can be problematic. Okay, so next slide. The final thing that we're seeing a lot of is frequency of pay for manual workers. So in New York, manual workers in the private sector have to be paid weekly. You cannot pay them semi-monthly. You cannot pay them bi-weekly. It has to be weekly. And the pay date has to be no later than 7 calendar days after the end of the week in which wages were earned. There is a potential exception where very large employers, we're talking about 1,000 plus employees, can apply for an exception permitting them to pay semi-monthly. But again, that's only a small number of employers and you have to actually apply and get the exception. So most private sector